SJC-12110, Commonwealth v. James Garvey.
Thanks.
Mr. Hillman, welcome back.
Good morning again, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth. With me this morning is Kathleen Celio, who is the trial prosecutor down below. We're asking the Court to reverse the order dismissing the habitual offender indictment against Mr. Garvey. When the judge dismissed the habitual offender indictment in this case, she ignored the very plain language of the statute and, in fact, read words into the statute that just don't appear.
Can you consider the title?
Certainly, a method of statutory construction is considering the title, but what I would say in this case is that the term habitual is defined by the very words of the statute. Right in the plain language of the body of the statute, it defines habitual offender as a person who has 2 prior convictions and who's been sentenced to 3 years in prison. And that's really what controls here. It's one of the basic tenets of statutory construction.
Mr. Hillman, the first part of the statute, I get your argument about the plain language, and the second part, paragraph B, does deal with specific instances. What do you say to counsel's argument that it doesn't make sense because you could have someone in a narcotics offense, for instance, subjected to harsher penalty than someone that, as a habitual offender, than someone who has a violent crime?
Well, I think that the fact that the legislature used the words specific or distinct offenses in Section B shows, first of all, that they know how to use those words when they intend to. But I think, second of all, Section B, the purpose of Section B is to penalize those people who have been committed of certain prior offenses. And Section B has additional language and additional requirements that if you meet the requirements of Section B, you are unable to be paroled, probation, furloughed. So none of those options appear in Section A, which means that a person who's convicted under Section A can be considered for parole. They can be considered for probation.
Section B is a harsher.
That's what I'm suggesting, Your Honor. Thank you. Yes. And as I said, the legislature specifically knows how to include the language that would require that the offenses be separate and distinct when it wants to do so. It does so in Section B. It does so in the ACC statute. It does so in the Common and Notorious Thief statute. It knows how to do so, and the fact that it didn't do so here indicates its intent that all that is required to be considered as a habitual offender under Section A is that a person have 2 prior convictions for which they are sentenced to state prison for 3 years.
And even if it's on the same day?
Even if it's on the same day, Your Honor, absolutely.
And how does that make it, I mean, it does not ask us to essentially ignore the use of the term habitual?
No,
not only in the heading, but it's in the statute itself.
Agreed, Your Honor, but as I stated, the term habitual is defined within the body of that statute.
But that's what you, I mean, but that's sort of conclusory, isn't it? I mean, that sort of said the word means nothing. It's just a word to describe somebody who has been twice convicted, even on the same day.
And that's specifically what the legislature said. It's not conclusory. It's the way that the legislature determined to define a person who's been deemed a habitual offender under Section A.
If we don't think that it's so crystal clear what that means, wouldn't the rule of lenity play a role here?
No. Well, the rule of lenity, I would suggest, is used frequently or cited frequently by defendants when
by this court, too.
well, I agree, Your Honor. I agree.
I have to say it was overused, and you didn't want to apply to us.
Yeah.
Don't take it personally, but I might.
Thank you, Your Honor. I would suggest that the rule of lenity applies where the statute is ambiguous. And here, the statute could not be more unambiguous. The legislature used specific terms. They know how to use other terms when they want to, and they didn't apply them here. And I would urge the court to go back and look at the history of the habitual offender statute going all the way back to the early 1800s.
I did, and I read the case that was written in
1900.
1900, it's in, yeah. And I thought, at least as the description of, by the court in that case, I thought it was reading the statute as the defendant does here. I did.
I disagree, Your Honor. The way that I read Richardson, which is the case from 1900,
Right.
Richardson goes through kind of the statutory history of the habitual offender statute that was at least in place at that time. And they note that in 1832, the legislature amended the statute to require that the prior convictions be several to one another. The very next year, and then in 1833 and then in 1836, they rewrote the statute, and they did away with that provision of the statute that required that the convictions be several to one another. And in Richardson, this court basically said, all that is required is that a person meet the statutory definition, which is 2 prior convictions for which the person had been sentenced to state
Now,
prison.
I have a note here that in Richardson, the predicate offenses occurred at different times and places, however. So was that part of the basis for the courts not really having zeroed in on that?
Well, I would suggest no. I would suggest that the court in Richardson, and I agree with you, that the 2 prior convictions were separate. They were from the same sitting of the court, but they were separate offenses committed on different dates. But the point that this court made is that all that is required is that a person be convicted under the terms of the habitual offender
So
statute.
we didn't just assume, based on the facts there, that something else was at play.
That's right, because the defendant made the specific argument that in order for him to qualify as a habitual offender, the convictions and the sentences had to be several to one another. And that's what this court was looking at. It said, no, he had 2 prior convictions that qualified under the statute, therefore he's a habitual offender.
Counsel, I like the way Judge Billings succinctly put the question. He said a spree is not a habit. And I confess that that's a very appealing way to think of the meaning of habitual. So how do we get past a spree not being a habit? I mean, that's very compelling.
I don't think you have to, because I think what the court's job in this case is to look at what did the legislature intend by looking at the plain language of the statute.
Well, Judge Billings is suggesting that the legislature meant that a spree is not a habit.
Yes, and I respectfully disagree with the decision and Judge Ball's reliance on that decision, because as I've already stated, the habitual offender statute is self-defining. It says what a person needs to do to be considered a habitual offender. And where the legislature has used those specific words and defined what a habitual offender is, or who qualifies as a habitual offender, reading language into the habitual offender statute that just isn't there, as I would suggest the motion judge did in this case in reliance on the Peters decision, is just inconsistent with the legislative intent.
Understanding that that's the plain language of the statute, how does this make sense, just practically speaking? How does it make sense for you to have 2 convictions at the same time regarding the same things qualify you as a habitual offender?
Yes, Your Honor. So this court has, strike that. The legislature has the authority to criminalize in different ways the same conduct. In other words, the same act can violate many different criminal statutes. And the legislature has and can authorize punishment for each of those crimes, even if it's based on the same act. What the legislature is doing here is telling or is establishing a punishment scheme for a person who has committed 2 prior offenses that were so serious, regardless of when they were committed, two prior offenses that were so serious that they warranted 3 years in state prison in order to qualify them as a habitual offender.
Now, I know that that's one aspect of this, but you're also saying that there was a usurping of a fact-finding function here by Judge Ball.
Yes, Your Honor.
Now, was there evidence that you put in at some point, if not before the grand jury, at least before Judge Ball, to suggest that there had been something serial, or what was it about these prior convictions that you wanted her to know?
Yes, Your Honor. So I'll point out first by saying in the grand jury, the grand jurors were just given the prior convictions.
So they would know what they were.
They knew what the offenses were and the date that the defendant had been convicted of the prior offenses.
Okay, and we know that from the grand jury testimony?
Yes, Your Honor. Now, in front of Judge,
Date of conviction or date of offense?
date of conviction, Your Honor,
But not date of offense?
not date of offense.
But it was in fact one day, right?
Yes, yes. And so in front of Judge Ball, the defendant attached to his memorandum, and this is at pages 65 and 66 of the Commonwealth's appendix, the statement of the case from the prior convictions in Middlesex. So there were 3 crimes that were involved with an armed robbery and kidnapping, and then there was, I would suggest, the prior offense or a separate offense of receiving a stolen minivan that was used in the crime.
But the
That's
crimes were all the same date?
Same date.
But they happen in different, receiving the stolen motor vehicle, the contention was that was in Somerville, and the robbery was in Arlington.
Yes, Your Honor, and those are all questions that should be considered by a fact finder. If we're going to go down the path of requiring that the prior convictions be based on separate and distinct offenses, which is, again, a point I don't think this court needs to reach, but if we're going to go down that path, that's a question for the fact finder, not for Judge Ball.
Shouldn't it have been put before the grand jury is the question?
No, for 2 reasons. First is,
Well, you didn't know, but okay, getting past that.
second is that at the grand jury stage, we're only talking about probable cause. And probable cause of the elements of the offense only require that the grand jury be told of the prior convictions and that the person was sentenced to 3 years in state prison, which they were in this case. The gradations of whether the offenses were one criminal episode are gradations that should be made by a fact finder after a trial, not in the grand jury stage.
Could I just ask you, let's just
Absolutely.
assume that hypothetically that the statute is ultimately interpreted to mean it has to be different offenses, different occurrences.
Yes.
And in fact, they all get wrapped up in one plea, but they were different occurrences. And you put into the grand jury this one date. But if in fact the other side, that they all the offenses, put the minivan aside, but all the other ones are happening same time, same date, part of the same, doesn't even qualify as a spree, same criminal incident. You know that all you put into the grand jury is the date of conviction. Would it not be proper to say you need to put into the grand jury the evidence that shows it actually was on different dates?
I would say that the safeguard against that would be a motion for a required finding of not guilty at the fact-finding stage, not at the probable cause
Isn't
stage.
that fundamentally unfair because you're now having a defendant face the prospect of a habitual offender? I mean, it fundamentally alters the negotiating posture in a situation in which you, the prosecutor, are in a position to know that it'll be dismissed. I mean, how could a prosecutor in good faith bring a habitual offender statute based on 2 convictions for the very same conduct, knowing that when the issue is framed to a judge, the judge will dismiss it?
I understand, Your Honor. Of course.
Do you understand, or do you agree that you
I
could not do that?
I understand your point, and I agree that certainly we can't, where we don't have a good faith belief to believe that we can meet the elements of a criminal offense, that's something that we should consider before putting evidence before a grand jury. However, if, again, there are questions, like I said, gradations of whether a fact finder could consider that the offenses were separate and distinct based on time, location, victims, those are questions that I would suggest need to be before a fact finder. I understand, Chief Justice, I understand your point, and I agree that certainly if we don't have evidence to satisfy all of the elements of the crime, that's a different question.
I certainly understand your argument that the legislature knew how to do this, separate and distinct, for armed career criminal, and they certainly knew how to make sure there were separate episodes for a common and notorious thief, and that we should just read the language. If that's not the case, quite frankly, I don't understand how it is that the presentation to the grand jury wouldn't have to include that there were separate and distinct acts. I honestly just don't understand the argument. Putting aside the charging decision and the impact on plea negotiations.
I see that my time is up. May I just answer the question?
Yes, of course.
Well, again, Your Honor, I would, the first point I would make is when we indicted the case, we were reading the plain language of the statute. But the second point I would make is that at the probable cause stage, what the jury has to be, the grand jury has to be apprised of is probable cause that all of the elements of the crime here have been met. And if the elements of the crime are that they are convicted on, have been twice prior convicted and sentenced to 3 years in prison for those prior convictions, the grand jury was told that in this case. I don't know if that answers your Honor's question.
It answers, it just doesn't change my mind.
If there are no further questions, the Commonwealth will rest on its brief.
Thank you.
Thank you.
Good morning, Your Honors, and Chief Justice Gantz. I apologize, first of all, for being late. I live in Southern New Hampshire, and I left my house at 6:45.
Way too late.
Welcome
way
to
too
Tell you
late.
something, you know, for me to be here at 9 o'clock, I need to leave at 6. But
Okay,
that's beside the point.
we get it. Don't spend your time on that, we understand.
I'm representing the appellee, Mr. Garvey. From reading my brief, you understand that my brief relies heavily on Justice Billings' opinion in Commonwealth versus Peters, and the cases cited within that opinion. And as you do know, of course, that opinion really represents the majority rule across the country. The minority rule is just the opposite, where multiple convictions on a single date, a single episode can't trigger the.
But when you say the majority rule, I assume there are different statutes worded differently throughout the country.
Yeah, well, yes, they are, Your Honor. And I'm mostly referring to the case law, the cases that I've looked at.
And in fact, we have different wording in our statutes.
Yes, Your Honor, yes.
Why we're here.
Yes, Your Honor. Well, the reasoning in the cases that are cited in Peters is that an offender should be given the time after he's committed an offense to reflect and possibly reform. Under my brother's argument, that just wouldn't be possible.
Why
Well, he
isn't
probably
that?
shouldn't have committed the crime that got him to court.
I'm sorry,
right?
Your Honor.
He probably shouldn't have committed another crime, correct? Allegedly.
Well, I think that's the meaning of
This is
I think that's what the majority rule is trying to say, that, you know, somebody commits a crime, he's incarcerated, hopefully he has time to reflect on that crime, what he's done, and hopefully reform. So under my brother's argument, that just wouldn't occur. You know,
Isn't that a
multiple-
policy argument? I mean, maybe even a compelling policy argument? And isn't Peter's, that's a wonderful policy argument, but when the legislature is talking about common notorious thief, they say 3 distinct acts. When they talk about armed career criminal, they
Yes.
talk about distinct acts. Here, the legislature decided to have a policy different than what Judge Billings thought was the better policy.
Yes, I got that statute from my brother yesterday. I guess if you look at statutory construction, you know, the 2 tenets is that statutes are strictly construed for the defendant, and against the Commonwealth, and any plausible ambiguity goes to the defendant.
Tell me one bit of ambiguity in the statute. Pick any one.
Well, I think the ambiguity is possibly that the statute is entitled habitual criminal. And I think habit, the definition of habit, is something resorted to on a regular basis, according to some type of habit, something that a person often does on a regular and repeated basis. So maybe that's the ambiguity I would say exists between the title of the statute and the body of the statute of at least subsection A.
Now, let's assume that you are right, that it can't be the same criminal act, and let's assume then that Mr. Hillman or Ms. Celio then go back to the grand jury and they offer evidence that says, well, this car, which may have been used as the getaway car, was actually received in a different town 3 hours before. Can they then proceed then with this statute?
I don't think so, Your Honor, because it's still, I'm assuming it's still part of the same episode. He stole the motor vehicle in furtherance of the other crimes, the 3 other crimes that he committed. But it doesn't seem to me that is worthy of some kind of distinction that it was a different criminal episode, although it occurred on the same date in furtherance of the 3 other crimes.
How do you know about the in furtherance of?
Well, I think he drove that. If I'm correct, I think he drove that to the scene of the crime, and I shouldn't have said that because I don't know for sure. So that's what I'm assuming. I apologize for not knowing that fact. I mean, majority rules is reflected in the federal statute on this subject. 924C, 18 U.S.C. 924C, and
Is that a ACC or is that a habitual offender?
that's habitual offender, Your Honor. And the federal courts look at, I think, at least three different factors: whether the violation occurred at different locations, were the crimes of substantially different nature, and whether the crimes involved multiple objectives of victims. And I think, again, that represents a majority opinion, a majority rule across the country. And the early cases, and I would probably look at McDonald versus Commonwealth, and there's something that I took and I put down in my notes, and they reasoned that only when the criminal habit has become so fixed in hope of reform so slight that a long continued imprisonment is justified. And that's an early case. That's 1899. So, back then, that was the thinking of the court. And I know that there was a change in that statute, 1932, 1933. But this was the thinking after the revision, after it went back to the multiple crime, possibly single episode statute that now is part of the law in Massachusetts.
Go back,
I'm sorry, go ahead.
please, Chief. Can we go back to 18 U.S.C. 924 E?
Yes.
Because in that statute, it says, right in the statute, on occasions different from one another. That's right in the language. So when you talk about the majority and the minority rule, when we look up these other statutes, are we going to see that it has language as included in the federal statute, on occasions different from one another?
Yes, Your Honor.
All right. So how
I
does
think
that?
all the cases that I have in my brief to support that say essentially that.
All right. And so how does that not hurt your position?
Well, I don't think it hurts me to say that the majority opinion and the opinion that that I'm arguing for, the position that I'm arguing for this morning is supported by a federal statute. I don't think that hurts my position, unless I misunderstood your question.
I think so, because in the federal statute, it specifically says that the prior offenses have to be on occasions different from one another, and in the statute we're looking at, it doesn't have that language.
That's right, Your Honor. So what I'm saying is that the federal statute is different than the statute we have now in Massachusetts. I'm sorry if I'm not answering your question.
Do we have, now, the original statute was passed in, what, 1832 or 23?
1832, I don't know if the original statute was in 1832, but in 1832, the status of the law was, it was episodic, it needed
Okay.
two
But
episodes.
we're talking about a statute done in the first part of the 19th century.
Yes, Your Honor.
And do we have, that I assume the term habitual offender is a term of art, and do we have anything from Blackstone or any of the commentaries that would have been relied upon then, which would have defined that term?
Well, Your Honor, I just, in my brother trial counsel, we just, habitual criminal, we looked up, trial counsel looked up habitual in Webster's, and that's the definition I read to you earlier. So that's, that's the authority we chose for what habitual means, something that has to be repeated on different occasions in a repeated way. And I have to say, Your Honor, is that, in reviewing the Commonwealth's brief, unless I missed one, I didn't see any cases that support their position that, I couldn't find a case where the statute was actually implemented or interpreted the way the Commonwealth is now suggesting. I looked at the brief, I researched all the cases, I did other research, I couldn't find a case. So, I don't know really how the statute has been used, interpreted in practice here, because I haven't found any cases that supports the Commonwealth's view. I found plenty of cases that support the majority rule. I mean, there are cases that the Commonwealth mentioned that, talk about, that the habitual criminal statute is, not cruel and unusual punishment. There are cases that cite to the fact that consecutive sentences don't, although they don't allow for a period to reflect and to reform, but in the same way, in the same light, those consecutive sentences are allowed under the habitual criminal statute. So, but I didn't find really any other authority, again, that tells me how the statute's been implemented now and in the past. I mean, the line of cases that I cite in my brief are State versus Tavares, Commonwealth versus Hall, People versus Spellman, Miller v. State, Hall v. State, and Porter v. Butler. And I think those are all mentioned in Judge Billings' opinion. And they all stand for that same proposition. And then you go back to Richardson in 1900, citing Hughes from 1892. It's the same theme. The object of the statute is to prevent the repeated commission, I'm reading right from the case, of repeated offenses by imposing severe penalties for each successive violation of law, and thus to save persons from becoming old and hardened criminals. So the part about old and hardened criminals, I mean, I don't know how you get from that point to a point where you punish somebody with an enhanced sentence for a spree, as put forth by in a Peters case. I just don't see how you can reconcile that. And
Okay, there are no further.
I guess in this case, if it pleases the court, I think that when my brother argues that, the grand jury, the Judge Billings was getting into facts versus substance. First of all, I think that what Billings did, what Judge Billings did, was not, he didn't play with the facts. It was really just an interpretation of law. So I think he was on firm ground in that sense. And also, I think I looked at Commonwealth versus Odell, and that stands for the proposition that the integrity of the grand jury process can be impaired by an unfair and misleading presentation to that body. I think that's exactly what we have in this case. And I think that actually what happened in this case with the grand jury and the Commonwealth, I think it was a pretty severe violation of my defendant's due process rights here. I think that
you may be right, but I assume you don't suggest that we need to find that the ADA acted in bad faith in order for you to win.
No, I just, I think that it would have been easy for the Commonwealth to give the dates of the offenses. I think it would have been a no-brainer. And I guess I just leave it at that. So I don't think the grand jury heard really all the facts here, and they didn't have the facts, I feel, to fulfill their duty properly.
Okay, thank you, sir.
Thank you, Your Honors.